Senator Blumenthal is next.
Thanks, Mr. Chairman. Good afternoon,
Good afternoon.
Judge Jackson. I know your birthday, September 14th.
Yes, sir.
You have the happy coincidence of a birthday with Constance Baker Motley,
Yes, sir.
who just happens to have been born in New Haven, Connecticut.
Ah,
And we're very proud that she is a daughter of New Haven and Connecticut. And she is one of my heroes as well. As you know about her, she was the first Black woman appointed to the federal bench. She is the first Black woman to have argued before the United States Supreme Court. In fact, her record before the court was 10 wins and 0 losses. She was very predominantly responsible for Brown versus Board of Education. Thurgood Marshall got most of the credit, but she did a lot of the work. Probably sounds familiar to you. So why don't you tell us, and maybe tell those folks, particularly women and girls who are watching or listening, why you said at the outset of the hearings here that she was one of those whose shoulders you stood upon as you came here today.
thank you, Senator. Well, in addition to the fact that we share a birthday, which I discovered when I was in law school and thought, what a happy coincidence in terms of someone who I so admired. And secretly at that point, I was thinking maybe I might want to be a judge. So it was a wonderful, wonderful coincidence. I so admired the fact that she was the first. It's not necessarily easy to be the first, but it is an opportunity to show other people what is possible. When you're the first, it means no one has ever done it before like you, and there may be hundreds, thousands of people who might have wanted that opportunity and thought, I can't do that because there's no one there like me. And so being a trailblazer, whether it's Judge Motley or Justice Marshall or Justice O'Connor, being a trailblazer is really inspiring, I think. And I was always moved by Judge Motley's experience and think it may even be part of why I moved in this direction.
Well, it is inspiring. And I hope that your very inspiring story will make it possible for a lot of others to think it not secretly, but say it out loud and aspire to it, because it's what this country needs. And fortunately, President Biden has recognized it in the nominees that he's put before us. And we've tried to work with the great leadership of Senator Durbin to confirm people of real merit, the kind of qualifications in intellect and character and depth and warmth that you bring to us today. I want to talk a little bit about voting rights, because part of the reason why those dreams now are realities is that more people have the right to vote, at least until recently. In fact, there has been a lot of backsliding about turning back the clock on voting rights. The gentleman sitting behind you, Doug Jones, our former colleague, whom we very much respect and admire, wrote a tribute to Vivian Malone Jones, who has a rich story as a civil rights warrior and who succeeded John Lewis as head of the Voter Rights Project. And he said in a speech that Doug Jones wrote in tribute to her as she was inducted posthumously into the Alabama Women's Hall of Fame, I'm quoting, We can best honor her by acknowledging that while most doors are unlocked today, they are still heavy and so hard to open for so many people in Alabama and the rest of the nation. Let us commit ourselves to do our part to open these doors as wide as possible so that everyone can take the walk that Vivian took. I'm going to ask that former Senator Jones' full speech be entered in the record, Mr. Chairman. Thank you. The simple fact of the matter is, Judge Jackson, Congress passed the Voting Rights Act in 1965. It was a source of real power to so many people who got the right to vote for the first time in practical terms, because it struck down more than 1,000 discriminatory election rules proposed by state and local officials. It opened the ballot box to millions and millions of Americans, and it became regarded as the crown jewel of the civil rights movement. And then, just in the last few years, the Supreme Court has hacked away at it in an exercise of judicial activism that has been historic in magnitude. Judges supplanting their views for the policy preferences and official acts of legislatures in opinions that were written and joined by only conservative justices. These decisions were about as far from judicial restraint as they could possibly be, not even close. And they rewrote the rules of our most cherished and most bipartisan civil rights laws. You know the cases: Shelby County, Brnovich versus Democratic National Committee. In effect, their opinions, including Justice Alito's decision in Brnovich, are completely untethered from the clear statutory text, and they impose a series of so-called guideposts on Section 2 that create unreasonably high hurdles to the exercise of the Voting Rights Act. I hope that you will bring to the court that deliberate, careful methodology that you described earlier very convincingly. It is part of your judicial philosophy in the sense that it's your approach to cases. And it has been very persuasively and clearly articulated. And I think if that kind of deliberate and careful methodology had prevailed on the United States Supreme Court, we would still have the Voting Rights Act in full right now. And I hope that we can once again return to bipartisan support of those rights. The most recent exercise of unfortunate decision-making in the voting rights area came just hours ago when the Supreme Court struck down the decision of the Wisconsin State Supreme Court in Wisconsin Legislature versus Wisconsin Elections Commission. What is striking is not only the result, but the fact that it was done as part of the shadow docket. We've talked a lot about it here, and what the people of America should know is there's no oral argument, there's only minimal briefing, there are no full opinions of the court. In fact, I'm holding up a per curiam opinion that is about 12 pages in length from the court, which means you don't know who wrote it. And there is a powerful dissent. I recommend that everyone read it. Again, use of the shadow docket has become increasingly prevalent since 2017, and in effect, the United States Supreme Court is shirking its duty. I hope you will bring to the court the kind of responsible and methodical approach to decision-making that will lead to an avoidance of the shadow docket, as well as a return to the Voting Rights Act. And if I can just offer one more piece of advice on the court's workload, I have a chart. I know we're not going by the rules of evidence here, but this chart indicates the signed decisions of the United States Supreme Court over a good part of its history. And I think the pattern here is pretty clear. The court issues fewer signed opinions. In fact, it has declined precipitously since 1972. This little blip at the end here is an increase from 53 to 57, but you can see it's only a fraction of what the court used to do in signed opinions. Even from the time when I was a law clerk, it's diminished profoundly. The Supreme Court needs to do its job. It needs to issue signed opinions, not the shadow docket. It needs to take cases and resolve real, fundamental, important issues. And taking your record, 573 opinions over 9 years. I'm not a math major, but that's about 64 opinions a year. That's a lot more than they do, all 9 of them. So I hope you will bring the energy that you have demonstrated in this room, the energy and the work ethic to the United States Supreme Court, because clearly you have both. And I think the court is very much in need of it, as it is some of the other great qualities, intellect, character, that you have demonstrated here. Just a couple more points, if I may. You were asked earlier about dissents. I want to ask you about one in particular. The dissent of your mentor and your predecessor on the court, Justice Breyer. I am told, I think I've read, that there is one opinion that he is proudest of. Could you tell us what you recall it being, if you know?
Senator, I'm not able to answer that question.
Well, I think he said that the dissent that he is proudest of was in parents involved in community schools versus Seattle School District. I think he said it was the opinion that he was proudest of. And he cited it in a Harvard Law School symposium about his notable opinions. And he said this dissent was most notable. I will give you the citation when we're done, and ask that it be entered into the record, Mr. Chairman.
Without objection.
It's 77 pages long, and it's a dissent. It's a dissent in the parents involved case, which was a 5-justice plurality invalidating public school integration plans in Seattle and Louisville. The plans had been in place for decades, put in place by 2 local school boards, voluntarily trying to address school segregation in public schools in both of those cities. And the justices, conservative justices, striking down the school integration plans, said in effect they couldn't move forward with those integration plans. You may recall it is the opinion where Chief Justice Roberts said, very famously, the way to stop discrimination on the basis of race is to stop discriminating on the basis of race. Justice Breyer, in dissent, which reminded me of a lot of what you've said here this week, wrote, quote, "I do not claim to know how best to stop harmful discrimination, how best to create a society that includes all Americans, how best to overcome our serious problems of increasing de facto segregation. But as a judge, I do know that the Constitution does not authorize judges to dictate solutions to these problems. Rather, the Constitution creates a democratic political system through which the people themselves, through their legislators, must together find answers. The court should leave them to their work." I think that's the philosophy that you've articulated here today, the judicial philosophy of separate branches of government, as you so eloquently described our constitutional scheme, our federalism that really should have led the court to respect the Wisconsin Supreme Court's decision and the Wisconsin governor's decision, and to stay in its lane, as you have put it so well. The fact is, there has been a lot of progress, and we see it in this hearing room. But there is a lot of work still to be done, and there's a lot of reason for folks to feel even some anger at what we've seen on voting rights and on resegregation in some areas. So I am really excited, as I've indicated, and joyful at the great landmark and the historic accomplishment that your nomination represents and reflects. And I hope, as I've said, that not only will you make the court look more like America, but hopefully think more like America. And I want to thank you for your very hard work, all of what you personally have done, because you as a person have done it. And history has given you this opportunity. Your parents have helped to make it possible. Your family story is so powerful, but you've really earned it. And we're grateful to you for providing all of us that role model. Thank you, Mr. Chairman.
Thank you, Senator Blumenthal. Senator Hall.